Civil law regulates the dispute in respect of rights and obligation between persons dealing with each other. The court does not punish the wrongdoers but imposes a settlement, either by awarding or granting injunctions or other orders. Examples of civil law are company law, family law, revenue law, employment law and commercial law. The following types of cases can be filed in civil courts: contract and tort matters, matters concerning trust, matters concerning mortgages, matters concerning partnership dissolution, custody of child, matrimonial cases, other family disputes such as inheritance. Criminal law is a body of law defining offenses against the community at large, regulating how suspects are investigated, charged and trialed, and establishing punishment for convicted offenders. Criminal law deals with crimes such as murder, terrorism, theft, robbery, etc. Pakistan has a federal parliamentary system of government with the President as the head of state, and Prime Minister as head of government. The federal legislation is a bicameral of Parliament, comprising of President, National Assembly, Lower House, and the Senate, Upper House. The legal system in Pakistan is based on the Constitution of Pakistan 1973 as well as Islamic law. The main sources of law in Pakistan are legislation. It is the law created by the Parliament of the country and other bodies to whom it has delegated authority. Precedent. Precedent is a judgment or decision of the court which are binding on the subordinate court. Custom. Certain practices and beliefs are so vital that they form part of a social and economic system that they are treated as if they are law. Agreement. Parties in their agreement stipulate terms for themselves which constitute law for the contracting parties. When National Assembly is not in session and President deems necessary to take action, he has the power to issue an ordinance. Such ordinance shall have the same force and effect as an act of the Parliament. However, the ordinance shall stand repealed after 120 days, if it is not presented or passed by the National Assembly. The role of Senate is to approve all statutes passed by the National Assembly, with the exception of money bill. A money bill may originate in National Assembly, and after it has been passed by the National Assembly it shall, without being transmitted to the Senate, be presented to the President for assent. In delegated legislation, power is given to an executive, a minister or a public body to make subordinate or delegated legislation for specified purpose only. For example, local authorities are given statutory power to make bylaws which apply in a specific locality. Control over delegated legislation is exercised by the Parliament, restricting or defining the power to make rules. Rules made under delegated power may be challenged in the court on the ground of being ultra-virus. The advantages are: time. Parliament does not have time to examine every matter in detail. Expert opinion. Much of the content in delegated legislation is technical and is better worked out in consultation with professional, commercial or industrial groups outside Parliament. Flexible. It is far simpler to amend a piece of delegated legislation than to amend an Act of Parliament. Disadvantage are: as delegated legislation can be produced in large amount, the volume of such lawmaking becomes unmanageable, and it is impossible to keep up to date. Delegated legislation also takes away lawmaking power away from the democratically elected members, to unelected civil servants, and experts working under supervision of government ministers. When a precedent has been overruled by a higher court and law for future cases has been changed, when a precedent has been overruled by statute, when ratio decidendi is completely obscure and cannot be clearly identified, when the facts of the case are materially distinguished from the facts of the previous case which created precedent. A judge is not bound to follow the precedent under the following circumstances. Overruling a precedent. A precedent established by a lower court can be overruled by higher court. The higher court set aside the decision of the lower court and the precedent ceases to apply. Making distinction between cases. A judge may avoid a precedent by identifying facts in the current case that make it different from previous case. If the facts are sufficiently different, the judge in the current case does not have to follow precedent in the previous case.